Hello everyone, it's Harry Sherrod here and welcome to video number 6 in my Employment Law Foundation course. Now in video number 5 I mentioned that constructive dismissal, so let's pick up on that theme again and look at that subject. Now an employee, generally speaking, has to be with the organisation for 2 years to be able to claim constructive dismissal. We looked at the 2-year qualifying rule in video number 1. In video number 2, we looked at some of the automatic unfair dismissal reasons which don't require the 2-year qualifying rule, and it is possible for an employee to combine one of the automatic reasons with a constructive dismissal claim, but that's relatively rare, a little bit more complex. So generally speaking, we are talking here about an employee with more than 2 years service. Now, an employee might raise a grievance, for example, might say my employer has been unfair, might say my employer has been unreasonable, and the employee might be justified in saying that. Does that mean they've been constructively dismissed? Answer is no, it doesn't, because that's not the test. The test is not reasonableness, the test is not unfairness. The test is breach of contract, and only if the employer has been in breach of contract can there be a constructive dismissal case. Now, there can be some pretty obvious breaches of contract. The employer doesn't pay a bonus that's due, or unilaterally demotes the person, or cuts their salary or whatever, but those things don't happen very often. Usually it's a more subtle assessment of the situation. In video number 5 we looked at implied terms of contracts of employment, and one of the most important implied terms in this context is the implied mutual duty of trust and confidence. So it's implied by the conduct of the parties. It's not written in, but it's implied that the employer and the employee will treat each other with mutual respect. If there is unfairness or unreasonableness of a serious degree, the employee may be in a position to prove that it is so serious it has actually crossed the line and it has now become a breach of the implied duty of trust and confidence. And if the employee can prove that, then that potentially is constructive dismissal. Now, I would say that the bar is set pretty high in a constructive dismissal case, higher than people realise, because again, it's the same point. It's relatively easy to demonstrate there's been some unfairness or unreasonableness, but it's more difficult for an employee to demonstrate that there has been a breach of contract. So that concludes number 6, and I look forward to speaking with you again next time.